Hey, good evening, everybody. Welcome in. We are doing the third part of our webinar series this evening. I am William King. I am the probate attorney and estate planning attorney at the Manili firm. And again, we are doing the third part of our webinar series. We are doing this in Spanish and English. So we're excited to have everybody in. 1 second, we're going to wait for our interpreter. That's going to be Sinceria Levesque. She's going to be handling the interpreting for us. So if you give me 1 second, we'll get her in here and we'll get started with our webinar this evening. But thank you for joining us, and we'll get started here shortly. Hey, Sinceria, we got you in?
I am in, but no video.
That's all right. We'll just do the interpreting here. So if you don't mind, again, welcome in, everybody. My name is William King. I am here with the Manili Firm PC, putting on the third part of our three-part webinar series on estate planning. Again, I'm the probate and estate planning attorney, and we are doing this in English and Spanish tonight. And I'm excited, and I'm glad to have Sinceria Levesque with us. She will be interpreting for us. Say hey to everybody, and thank you for joining us, Sinceria, and thanks for offering to interpret.
It's my pleasure. Buenos días, me llamo Senseria y soy la traductora aquí para este seminario de planificar patrimonial.
And just so everybody knows, this is a public forum, so don't share anything that's private or any information that you wouldn't want anybody else to know. We would certainly invite you to set up a consultation with our office. To do that, I can meet with you. We can go over your specific estate plan and what I would suggest in regards to setting up a will or other documents. But again, don't share any private information. Set up that consult. But if you do have any questions throughout, let's go ahead and shoot me those questions via the chat feature or the Q&A. Either one works. I'm happy to field questions during the webinar, and I will also leave it open at the end to allow for questions for a short period at the end of the webinar.
Este seminario está abierto al público, so por favor no pone su información privada aquí, pero si tiene unas preguntas lo puede poner en el función del chat o lo puede mandar esa pregunta al abogado con el función que se dice Q&A.
Wonderful, thank you. So let's get started. We'll jump right in. So tonight we're just talking general estate planning, and really what that means is we're going to talk about setting up your will or a trust. We're going to talk a lot about wills and a little bit about trust at the end, but what you should think about and what you need to get done, and especially to have in place, is a will. When you think about an estate plan, you think about a will. That means, what am I going to leave behind? What am I going to leave to my family members, my friends? This is a document that expresses your desire and how you want to leave your property and who you want to leave it to.
So, hablando sobre el planificar del patrimonial, está pensando en cómo, qué es que lo quiere dejar a las otras partes de su familia, de sus amigos, qué son las cosas que lo quiere tener a ellos. So vamos a hablar sobre eso. Primero, también hay otras formas de planificar.
So when you're thinking about who you want to receive your property, that's going to be a beneficiary. And you can have multiple beneficiaries. You can have one beneficiary. A lot of the things that we see as a spouse leave something to a spouse, to children, but you can leave whatever you want to whomever you want. So a family member, a friend, a charity, a business, anything like that, you can leave your property to whomever you would like.
So hablando con quién lo quiere dejar, su propiedad, las cosas de su vida, esos son las personas que son los beneficiarios. So lo puede ser como los padres, los hijos, amigos, lo que sean, pero son los beneficiarios del planificar patrimonial.
So that's the first thing to think about. Who do I want to leave it to, and what do I want to leave to that person? The second thing to think about is who's going to handle this for me, and that's what's called an executor or an executrix. That is the person that you have handle executing your will. They make sure that your wishes are fulfilled in terms of what you want done in your will. So you want to think through who that's going to be. You want it to be somebody you trust, somebody you know is going to follow your wishes, somebody who understands what you want done. But that's the next thing that you want to think about is who's going to be that executor or executrix. And you want to think through possibly having two. You might want to back up in case that first person is unable or unwilling to act. So thinking through that, you want to know who's going to be there to handle executing your will.
La segunda parte es pensar en quién lo quiere que sea el ejecutor de su propiedad, en qué tiene la confianza de entender sus deseos y que tiene su confianza total. Y también lo quiere pensar a tener dos personas. En caso que uno no puede, no tiene deseo o no puede ser el ejecutor.
So some other things to think about outside of who I'm going to leave this stuff to, what am I going to leave, who's going to handle this for me. There's some other things to think about within your will. If you have a child, you can set out, if something were to happen to you or you and your spouse, who do you want to take care of your child? You can set out who would be a guardian of your child in your will. That's certainly something that you want to think through when you're setting your will up. If you have children, especially young children, you want to think through who's going to be their guardian if something were to happen to me.
También lo puede pensar si tiene hijos menores, ¿quién le va a cuidar los niños? ¿Quién le va a ser el guardián? So, con las personas que tiene confianza en esos, lo puede poner en el planificar patrimonial, con quien usted tiene el deseo a cuidar sus niños.
And then the other thing to think about is if you have children or if you're leaving property to somebody who hasn't reached the age of majority or adulthood, is do you want to set up a trust for that child or those children, or you have the option to set up a trust for a pet? That's very interesting, something that we've done recently. You can set up a trust for a number of other reasons, tax implications, things like that. But one of the biggest reasons I see people set up a trust is if they have children and they're under the age of 18 and they don't want necessarily for them to have access to that money immediately, or they want somebody in place who's going to make intelligent financial decisions on behalf of that child. Setting out a trust in a will is certainly something that you can do, and certainly something I would suggest you do if you have children and you're leaving something to them in your will.
También, si lo tiene propiedad que lo quiere dejar a sus hijos menores, lo puede pensar en cómo lo quiere dejar, si lo quiere tener un guardián sobre eso, un ejecutor nomás para la propiedad, o también hay cosas que lo puede dejar a un mascota. Hay cosas que nosotros hicimos con eso también. So, hay varias cosas, lo puede ser por los taxes, por los niños, por las mascotas. Hay varias cosas y todo depende entre qué es que usted quiere.
And the other thing that I think is important to know outside of, kind of the pieces of who it is, what property you're leaving to whom, the other pieces of that is, who's going to handle your will, a trustee, a guardian, things like that. The other thing to think about is a will is very flexible. It can be as general or specific as you want. It can be as lengthy or as short as you want in terms of how detailed you want your instructions to be versus how general you want your instructions to be. So, for example, I leave everything to my wife. That could be your entire will. Or you can set out 20 different people that you'd like to leave something to, and it can be as specific as $15 on the first Tuesday of the month for the first 2 years after I pass, to $1,000 to this family member, $1,000 to that family member, my quilt collection, my stamp collection to this family member, my baseball cards to this family member. It can be as general or specific as you want.
La otra cosa cuando está haciendo el testamento lo puede ser bien general o como por ejemplo yo deseo dar toda mi propiedad a mi esposo o lo puede ser con muchos detalles que por ejemplo lo quiero dejar mi colección de estampas a esta persona, lo quiero dar $15 cada martes para 2 años después que me muero. Lo puede hacer cualquiera de que usted quiere.
So there's also the option that if you want to set out your property, your tangible property, clothing, furniture, collectibles, jewelry, memorabilia, things like that, you can set up a memorandum of personal property in your will as well, which leaves specific items to specific individuals. So that's another option that you have to again, be as general or specific as you want.
También lo puede tener una opción sobre la propiedad tangible. Por ejemplo, lo quiere dejar toda su ropa a este miembro de su familia. Por ejemplo, también es que lo puede ser general o con todos los detalles que usted quiere.
So those are the basics of a will. Thinking through, again, your beneficiaries, how general and specific you want to be with those beneficiaries, your executor, executrix, who you want to handle your will. If you have children, do you want to set out a trust? Do you want to have a guardian? Who do you want to name as the trustee of that trust? Those are the basics of a will. And it's very specific in terms of each person's situation on how they want to set that up. But generally, each will is going to have some form or fashion of these pieces. And certainly something that I would suggest everybody thinks through having in place, because it's very important to make sure that you protect your estate for the benefit of you and your loved ones, your friends, your family, things like that. So I definitely, say this is definitely something you want to think about having in place immediately.
Hablando sobre el testamento, es bien básico lo que decimos, que quieren pensar quién se van a ser los beneficiarios, quién se va a ser el ejecutor, si lo tienen niños, quién van a cuidar, quién se van a ser el guardián, y cómo lo quiere dejar su propiedad. Hablando sobre todo, es bien importante que tiene algo diciendo qué son los deseos de usted después que se muera. Es bien importante así que la familia no está peleando después.
So let's talk about execution, executing the will. You have to have, one, it has to be in writing. 2, you have to have 2 witnesses. And 3, something that we attach or that we do and that Georgia allows is a self-proving affidavit. And that's very important because that prevents you usually from having to bring in those witnesses in a court to testify that you in fact did sign the will. So again, execution, it's got to be in writing. You need 2 witnesses, and you want a self-proving affidavit attached to the will that the witnesses sign as well, which is very important for court reasons.
So, para ejecutar el testamento, hay tres cosas que necesita. Lo tiene que hacer por escrito, lo tiene que tener dos testigos y también lo tiene que tener algo firmado enseñando que los testigos han firmado en frente de usted.
So the other thing that is important to know in regards to the execution of the will is when you have to have two witnesses. The witness cannot be somebody who is benefiting under the will. Otherwise, that witness is invalid. So what that means is if you have somebody that acts as a witness to the will that is also a beneficiary of the will, it's as if that person never signed that document as a witness. And so then you don't have the two witnesses you need to make it a valid will. So it would invalidate the will completely. So you want to make sure you have two witnesses that are not inheriting, not benefiting from the will. That is a very important piece as well.
La cosa que también lo tiene que pensar hablando sobre los testigos, no pueden ser beneficiarios. Si uno de los testigos es alguien que le va a beneficiar de su testamento, se niega el firmado. So, es como no se firmó, entonces el testamento no está válido.
Okay, so I said we would talk about trust just a little bit, and we did a little bit in regards to the will, but trust can also be important when you are setting up a situation in which you would like to leave money to a child. It can be important in that situation. It also has a very important impact in regards to taxes. So there's a lot of tax implications when it comes to a trust. And then you also have the impact of whether or not you're going to go through probate court. So you can set up trusts outside of your will that would never have to go through probate court and could save time and money and costs in terms of going through probate. It just depends on your situation. And what I mean by that is when you have a will, you have to probate that will. It means you have to file documents with the probate court in order to probate that will and give your executor the power to handle everything that you need done. So a trust can essentially avoid that as well. So a number of reasons why you might want to have a trust in place.
So hablamos un poquito de la fideicomismo y con eso es más cuando estamos hablando sobre el dinero. Con eso después lo tiene que ir en frente de un tribunal del probate. Y con eso hay varias cosas que lo pueden afectar y lo pueden negar si es necesario de ir en frente de un tribunal.
So, again, I cannot stress the importance of having something like this in place, whether or not it's a will or trust, whatever that may be. I cannot stress the importance of having something like this in place because it takes a lot of stress off your family, off of you, knowing that your estate, that your future, your family's future is safe and secure, and that there's not going to be a question of what's going to happen to your property when something happens to you. So it's very important to have these documents in place. It's very important to meet with an attorney to go over those documents and make sure that everything is tailored towards you, what you want, your family, what you think you need for your family. So I can't stress enough how important it is and how important I feel that it is that you have something like this in place.
So, nosotros no podemos parar de decir la importancia de tener algo así si algo se pasa a usted. Es bien importante porque le pone sus deseos para su familia, para sus amigos y para usted. Se quita el estrés de todo eso, de saber. So nosotros no podemos parar de decir la importancia de tener algo diciendo sus deseos.
Well, thank you for joining us tonight. Estate planning is something that I'm very passionate about. I I can't stress enough how important it is to have these documents, a will. You know, we covered power of attorneys, advanced healthcare directives, how important it is to have those in place. So please contact us. We'd love to do a consultation with you to go through your estate plan, to work through those documents, to work through your situation and make sure you have that in place. So that way your future is your future, your family's future, your friends' future, the people that you care about, their future is safe and secure. So please contact us. You know, let me help you get your estate plan in order.
Tenemos mucha pasión hablando sobre este. El abogado King tiene mucha experiencia haciendo casos así. Y si lo quiere una consulta, lo puede llamar a nuestra oficina a 770-421-0808 para hacer esa consulta. Como digo, tenemos mucha pasión sabiendo que estamos ayudando a las personas, los amigos de ustedes, a su familia y también a usted.
And just so you know, we're doing a special offer. Typically we do a consultation fee of $235, but if you contact us by close of business tomorrow, 5:30, August 21st, 2020, we will waive that consultation fee and do a free consultation so we can talk to you about your estate plan. So again, contact us before 5:30 tomorrow, August 21st, 2020, and we'll waive that consultation fee so we can meet with you and work on your estate plan.
También estamos ofreciendo un especial con la consulta. Normalmente tenemos un gasto de $235, pero si llama a nosotros antes que nos cerramos mañana, agosto 21, a las 5:30 de la tarde, lo podemos hacer la consulta gratis. Otra vez, la consulta gratis. Si llama a nosotros antes de las 5:30 mañana, agosto 21.
And now I'll open it up for questions. If anybody has any questions, I'll take those. We'll leave it open for a few minutes to do some questions. Again, thank you everybody for joining us tonight, and I appreciate it. Thank you, Sinceria, for interpreting for me. And thanks everybody for joining. I'll leave it open for a little bit for some questions.
Estamos dejando para, si tienen preguntas, lo puedo poner en el chat o en el botón que dice Q&A. Y tenemos tiempo para dar las respuestas de sus preguntas.
Okay, so we had one question come in. It says, can I disinherit people in my will?
Tenemos una pregunta que dice si lo puede negar alguien en su testimonio de ser parte de la herencia.
The answer to that is yes, you can disinherit people in your will. The benefit to that, or what you can do there is one of two things, and I've seen it done different ways, but you can specifically disinherit somebody saying you're not going to leave them something. And that way, if they try to challenge or take something from the estate, there's something in writing that shows you specifically didn't want them to receive anything. And that can be an estranged family member, something along those lines. That's something I've seen. The other thing that I have seen is somebody will leave a very small amount of money, $1, $5, $10, so they can show the court, the world, that they specifically thought about that person, but they didn't want to leave them really anything, but they specifically thought about that person and left them just a little.
La respuesta de la pregunta, si lo puede quitar la herencia de una persona, es sí. Lo puede mencionar que no quiere esa persona tener nada de su propiedad, o también hay otras formas que lo puede decir por escrito ahí, diciendo que nomás lo quiere que tiene $1, $5, $10 solo de su propiedad, que lo puede ser parte de la herencia de esa persona.
We got another question. It says, what does my family have to do if I don't have a will?
Tenemos otra pregunta que dice, ¿qué es que la familia tiene que hacer si no tengo un testamento de herencia?
There's two pieces to this. The first is that if you don't have a will in place, you have to file for somebody to administrate your estate. What that means is somebody can file with the probate court of the county that you passed away in, or where you resided, and they probate to administer your estate, which means they go in and they handle your estate. And that might be somebody that you didn't want to handle your estate, but it's certainly going to add a lot of tension and cost to what's going on. And the second piece is, and I'll get more into this after Sinceria interprets this initial part, but the second piece is you're also going to have to deal with laws of Georgia as it relates to the administration of an estate without a will, and that might necessarily not be something you want as well.
So, con la respuesta, con la pregunta, ¿qué es que mi familia tiene que hacer si no tengo un testamento de herencia? Hay dos partes. La primera es, alguien lo tiene que poner en frente de un tribunal. ¿Quién le puede ser administrador? Y con eso hay varias cosas que lo puede afectar. Lo puede ser bien gasto con todo haciendo. También hay la posibilidad que haya la persona que es el ejecutor de todo, es alguien que usted no quiere de hacer eso. La otra cosa con eso es, también lo tiene que tener sobre las leyes de Georgia y cómo se pone con su testamento de herencias.
So the second part of that you have to think about is what we talked about earlier. In a will, you can be very, very specific about who you want to leave your property to. But if you don't have a will in place, you fall under this category of intestate law in Georgia, which means that you pass without a will. And under that, it has a specific list of how your property is to be distributed to specific beneficiaries. It's first a spouse, then spouse and children. If you have children, if no spouse, then the children, if no children, and on down this list of potential beneficiaries, but it takes it out of your hands and puts it into the hands of the law. And so you may have property that goes into places or to people that you don't want it to go to. So it's very important to have a will in place, because then you're making the decisions on where your property goes versus the state.
So, hablando un poquito más sobre el segundo parte de la respuesta, hay las varias cosas con eso, que si usted no tiene un testamento de herencia, los otras personas lo tienen que ser el ejecutor, y con eso hay las varias cosas. Hay algo en las reglas que está diciendo que es intestate, y eso nomás está diciendo que se murió y no tiene un testamento de herencia. Y ellos tienen un lista que lo tiene que ir con diciendo cómo lo pueden hacer su propiedad, con quién lo pueden dar. So, se comienza, si está casado, se va con la esposo o esposa. Si tiene niños, después de eso, y se va abajo con ese list hasta que se tiene un resultado de eso. Y con eso hay la posibilidad que hay personas que usted no quería recibir algo, que están recibiendo su propiedad, el dinero, lo que sea. So es bien importante a tener un testamento de herencia diciendo los detalles específicos en qué son las personas que usted quiere tener, que son los beneficiarios.
I don't see any other questions, so we'll go ahead and wrap up tonight. Again, thank you for joining us for the third part of our three-part webinar series on estate planning. This was English and Spanish, which I was very excited to do. We will do this again. We'll be continuing to do webinars in the future, so if you missed one, If you're looking for some additional information, feel free to join us again. And I want to say a big thank you to Sinceria for joining us tonight and doing and interpreting for us. Thank you, Sinceria. And thank you, everybody that joined us. Have a wonderful evening and stay safe.
Muchísimas gracias por estar aquí con este seminario. Es el tercer parte del seminario de planificar patrimonial. La primera parte, nosotros hablamos sobre haciendo un testamento de herencia. Perdón, fuimos hablando sobre quién le quería hacer I just forgot. So, hay otras partes de este y muchísimas gracias por ser parte de este.
Thank you. Have a great night.
Muchísimas gracias. Adiós.